Good morning, good afternoon. I guess both would work since this is, I think we are right at 12 o'clock noon here on this Thursday. What are we? We are Thursday, April 8th. So happy Thursday to you. Bill O'Leary here from Legacy Planning Law Group coming to you live. And this is part of what we call our Thirsty Thursday series. So every Thursday at about this time, I'm going to come to you live here on Facebook talking about a topic that relates to sort of what we do at my law firm, estate planning and elder law and estate administration, that sort of thing. So if you're thirsting for knowledge, you've come to the right place. Today's topic is what happens if my trust is not funded? What happens to my trust if it's not funded? Well, let me back up and sort of paint a picture in your mind as to what a trust is. What is a trust? Well, a trust really is nothing but a box. So when you have a trust, congratulations, you have built a box. You've built a box, okay? And inside that box, or as part of that box, you are taking charge to answer four very important questions that are very personal to you. Number one, you are deciding who gets your stuff. Number one, who gets your stuff. Number two, you decide what they get. Number three, you decide when they get it. Number four, you decide how they get it. Who, what, when, and how. Very important, though, that you go through the exercise of answering those questions the way that you want, because if you don't put those down on paper, guess who answers those questions for your family? The state, the government. So I like to keep them out of the picture. This is your plan. You don't want to force the government's plan onto your family. Now, as part of that trust, again, it's a box. A very, very important step in the process of putting a trust together for the trust to work is to put your assets in the trust, basically putting your stuff in the box, okay? And and if you do that, and do that correctly and get the proper help to make sure it's done correctly because it's done wrong all the time, then a trust will work for you the way that you want. What do I mean by that? Well, the primary purpose for putting a trust together, what we call a revocable living trust, is to make sure that your loved ones are not going to be stuck in the probate court after you die, which is really kind of a really long, drawn out process, and it's very expensive. Lawyers, do well in a probate matter, but not so much the family. So it's a great way to make sure that they're not bogged down in the court system, your loved ones. But that's only going to work for you like that. The trust is only going to work the way it's intended to if your trust is fully funded. So what does funding mean? What does funding mean? To fund an asset into a trust. What does that mean? Well, typically that means taking an asset and moving it into the box, changing the ownership to the box, retitling the asset to the name of your trust. So if your name is Smith, and the name of your trust is the Smith Living Trust, dated, today's date, April 8, 2021. Retitling that asset into the name of the trust. So then the asset will not be owned by you anymore, but will be owned by the Smith Living Trust, dated April 8, 2021. And so that's commonly done. If, let's say we have a real estate, real property, well, a new deed has to be drawn up, and that's going to reflect the new ownership in the name of the trust. Okay? That's also done, let's say, with bank accounts or financial accounts, like investment accounts. Okay? So we'll take that account, and you as the client will go down to the bank after some sort of instruction from us, some help from us, and to say to the bank, hey, I have a trust. I also have a bank account with you. I want to change the ownership of the bank account to the name of the trust. To the name of the trust. And the banker will say, great, happy to help. We deal with trust all the time. Just give us a couple of things that we're going to require, something called a certificate of trust, etc. We help you with all that. And they go ahead and change the ownership of the account. So then the account whether it's the bank account or maybe the brokerage account at Fidelity or Vanguard or Schwab, whatever it might be, is now owned by the Smith Living Trust dated April 8, 2021. Now, I want to come back to that word funding. Funding, and if you do any sort of Google research, you'll see that term used quite often to describe the process of moving assets into a trust. Let me just share with you sort of my philosophy or my approach. I think sometimes, lawyers can be sort of lulled into sort of a one-size-fits-all sort of cookie-cutter approach. Okay, and so you got client number one walks in needing a trust. The trust is put together. Client two needs a trust. Client three needs a trust. And when it comes time to sort of the assets being moved into the trust, each client is treated the exact same. But that's not what we see in real life. That clients are different, situations are different. So what we try to do is implement sort of a more comprehensive or more holistic approach to a client's assets to accomplish two objectives. Number one is to make sure that those assets are going to go in a way that's consistent with their estate plan. In this case, let's say a trust. It's going to sort of flow through the trust the way that they have laid it out. Okay? And that might be as simple as, well, when they die, everything's going straight away outright to the kids, but it might also involve a situation where the parents want to protect the inheritance for the children, and so it's going to stay in a trust after let's say they die or the second spouse dies. It's going to stay in a trust for the kids in a way that the kids can still be in control of their own trust. It's a wonderful tool that I really especially enjoy talking to parents with adult children about, and boy, they just light up and they say, "Gosh, this sounds like having your cake and eating it too." And I say, "Yeah, you're right, it is." But so again, it is number one objective is to have the assets flow through the trust the way you've laid out the trust. Objective number two is to try to protect those assets as much as possible. Try to protect those assets as much as possible. And so a client may have a situation where they want to protect their assets from potential creditors. Think the car accident that they get into, and it's a bad one, and you've got a plaintiff's lawyer coming after you and trying to get your assets because there's not enough insurance to cover the claim and that sort of thing. Well, they want to protect the assets, and when you have a husband and wife, there are great ways to sort of protect assets. Well, we also emphasize that as well, to say, hey, while you're still living, let's make sure that the assets are protected, but at the same time, we're going to make sure that they flow through the trust the way that you have laid it out. So it's for that reason, sort of the additional focus on the asset protection, something that I have found most lawyers don't really focus on. They just focus on the cookie cutter. Let's just put the assets in the trust sort of across the board. Since those two objectives are sort of equal importance in our planning, I don't like using the term funding a trust. I don't like it because to me the term funding means changing the ownership of an asset into the box, into the name of the trust. Well, there's some assets that we don't move into a trust, retirement accounts, life insurance, annuities. There are other assets that we could move into a trust, such as, let's say, a joint bank account, joint brokerage account, but maybe we won't have the client do that, because if that was done, it would create sort of an asset protection weakness. So we might keep that outside, but we will align the beneficiary designation so it flows through the trust, let's say at the second spouse's death. So for that reason, I prefer using the term asset alignment, to align the assets. And depending upon a client's situations, that alignment may take the form of changing ownership. It may, or it may also take the form for some other assets. Let's not retitle the asset into the trust. Let's keep it outside, but let's align the beneficiary designation. So as part of the asset alignment that we do, which, by the way, most lawyers don't help a client do this, and a client sort of is on their own. A lot of times the client doesn't realize that it's their responsibility to align their assets with the trust. They think the lawyer just handled it, the lawyer did whatever needed to be done to make things legal, and didn't realize the lawyer did not take that on within the scope of the engagement, because frankly it takes the lawyer time and effort to do that, and so most lawyers I have found simply don't do that, and leave it to the client. We do that. We sort of take on that responsibility, build it into our pricing, but take on that responsibility to help a client do that, to make sure it's done and done right, and so we don't create another statistic, of which there are many around. People have a trust and no assets are in it, and they're shocked years later to find out that's the case. And so again, asset alignment is the term that I like to use, to capture both scenarios. Sometimes moving assets into the box, other times leaving an asset outside of the box, but aligning it so that it ends up flowing through the box at death, or in the case of a married couple, at the second spouse's death. And so let's talk about that statistic. The person that has a trust and there are no assets in it, or no assets that are aligned, nothing. What's the result of that? That's the ticking time bomb. That's the ticking time bomb. Because what's going to happen is when that person dies, the family may very well find themselves stuck in the probate court system, something that mom or dad who just passed away was trying to avoid for the kids. Okay, so mom or dad kind of wasted their time and their money doing that. They didn't quite get to the finish line. And it's funny, a couple times a year somebody will come in and ask me to review a trust that maybe somebody else put together for them, and I'll look at it and I'll say, this basically works. I'm not going to reinvent the wheel for you just to do a new trust for you. This works. Maybe we can adjust this or that, but it basically works. But then I'll always ask that follow-up question. Hey, are your assets aligned with your trust? Are your assets in your trust? And they give me this blank stare. What do you mean? What do you mean? The assets in the... Well, I have to assume the lawyer did it. The lawyer did the trust. Whatever needed to be done to make it legal, right? Wrong. Oh, I didn't know that something had to happen. Or maybe some people think sort of the moment they sort of put their signature on the legal trust, that the assets magically got into the trust, like waving a magic wand. Not true. Something has to happen. Effort has to be put in. Applications have to be filled out. Maybe those applications get rejected and have to be resubmitted. So it takes time and effort. And again, why most lawyers don't help a client do that is because the time and effort that it takes requires a lawyer to hire staff. And they've just adopted the business model. It's not right or wrong. They don't want to hire somebody. That's perfectly their prerogative. We have an asset alignment coordinator on staff, Courtney Roca. She is fantastic, and she comes to the office every day with that sort of on the front of the brain. Let's make sure this is done and done right for clients. So there you have it. So hopefully that gives you a little better insight as to what happens if my trust is not funded, or what happens if my assets are not properly aligned with the trust. Now, if you'd like to know more about that and maybe how we can help, I invite you to go ahead and have a complimentary 15-minute sort of discovery phone call with us, okay? You can go ahead and schedule that. Just go to the Book Now button on the Facebook, on our Facebook page. And it'll give you some times to select, and the purpose for this call is, number one, for us to start a conversation to see whether we'd be a good fit, and two, to have you tell us, gee, why are you scheduling a call with us? What's on your mind? What's your concern? What do you want to accomplish? So that way we can tell you if we can help you. So again, you can use the Book Now button or just Google us, Legacy Planning Law Group. So hey, if you've enjoyed this talk, I'd really love it if you could like the video. Better yet, share it with your friends. I'm trying to get the word out, and particularly on this important topic of making sure assets are properly aligned with the trust, because so many people have this wrong, and they don't even realize it. So I'm really trying to get the word out. So if you could share it, that'd be great. So again, I hope you've enjoyed this talk. You know, what happens if my trust is not funded? I plan on giving another talk next Thursday about this time as part of our Thirsty Thursday series. Same day and time, just a different topic. So if you're thirsting for knowledge, I am going to quench your thirst. So Bill O'Leary signing off for now on behalf of everybody here at the Office Team Legacy. Go make it a great day.